Let's just cross over live and listen in.
The following orders: that the respondent be detained for 7 days to enable the police complete investigations. The application is supported by the grounds in the body of the notice of motion and a sworn affidavit by number 71306, Corporal Robert Nyangao. The application is opposed by the respondent through counsel Elias Mutuma, Ken Echesa, Kikoech, Waiganjo, Okiro, and Peter Ouma John for the respondent. The matter came up for hearing on the 10th of January 2022 at 4 p.m. The counsel for the prosecution, represented by counsels Marlene, Kibiru, Jamsumba, and Ms. Wamboi, have submitted that the state is seeking to have the respondent detained for 7 days. The respondent was arraigned in Eldoret by the DCI officers from Nairobi, and it was not possible to compile a file and charge the respondent. The proceeding has stated that they have not been able to compile the cyber forensic analysis, and statements have not been recorded from potential witnesses. The prosecution also states that the utterances by the respondent are likely to stir ethnic tension, and the prosecution has stated that they require 4 days to complete investigations in order to charge the respondent. The prosecution relied on Article 49(1)(f), which provides that an arrested person has the right to be brought before court as soon as possible, but not later than 24 hours after being arrested. And if the 24 hours ends outside an ordinary court hours or on a day that is not an ordinary court day, then the end of the next court day or the day that is not an ordinary or the end of the next day. The respondent submitted through counsel Mutuma and Echesa that an accused person or an arrested person has a right to be presumed innocent and has a right to liberty and freedom of movement. The court can only curtail the rights where there are compelling reasons. And an arrested person has a right to be presented to court before 24 hours from the time of an arrest. Counsel for the respondent submitted that the prosecution breached the Constitution by presenting the accused person to court beyond the 24-hour time limit. Counsel for the respondent also submitted that the respondent is a senator elected by the people of Meru and does not live in Eldoret. He does not have a home in Eldoret, and the prosecution has not demonstrated how the respondent will interfere with the witnesses. The respondents relied on the cases of Republic versus Juma Wanjala, Kipchumba Sudi Oscar versus the Republic through the National Cohesion and Integration Commission, and Michael Rotich versus the Republic. And this is the court's determination. I have considered the application, the affidavit. So I have considered the application, the affidavit by PC Nyangao, by Kopro Nyangao, and the submissions by both the defense and the prosecutions. The main issues for determination are: 1, whether the respondent's right to liberty can be limited under Article 49(1)(f) of the Constitution. Number 2, whether the respondent's right to liberty, Number 2, whether the prosecution has established compelling reasons to limit the respondent's right to liberty. Number 3, whether the prosecution has informed the respondent of the reasons for his detention. The prosecution has submitted that the rights under Article 49 are not absolute and can be limited, and counsel for the applicant raised the issue of fundamental rights of an arrested person as provided for under Article 49 of the Constitution. The Constitution is clear that an arrested person should be brought before court as soon as reasonable and not later than 24 hours. And I'm satisfied that the prosecution has not breached the right of the accused persons, because the respondent was arrested on Sunday, and the time which the respondent was arrested was not official court working time. Article 49(1) of the Constitution gives a suspected person or an arrested person a right to bail, and it states that an arrested person has a right to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons to be released, not to be released. It is clear from the wording of Article 49(1)(h) that the right is not absolute and can be limited where there are compelling reasons. And the limitation of a right to liberty of an individual must also be in accordance with Article 24 of the Constitution, which provides that rights or fundamental freedoms in the Bill of Rights shall not be limited except by law, and then only to the extent that the limitation is reasonable and justifiable in an open, democratic society based on human dignity, equality, and freedom. And in limiting the right to freedom of an arrested person, the following factors must be taken into consideration: the nature of the fundamental freedom, the importance and purpose of the limitation, the nature and extent of the limitation, the need to ensure that the enjoyment of rights and fundamental freedoms by any individual does not prejudice the fundamental rights and freedoms of others. The relation between the limitation and the purpose, and whether they are less restrictive means to achieve that purpose. I'm also guided by Article 50 of the Constitution, Article 52A, which includes the right to be presumed innocent. I'm also guided by the case of the Republic versus Danson Mugunya and another, a 2010 Kenya law report, where the court stated that liberty is precious and no one's liberty should be denied without lawful reasons in accordance with the law. And we must interpret the Constitution in enhancing the rights and freedoms granted and enshrined rather than in a manner that curtails them. I'm also guided by Article 21, Sub-Article 1 of the Constitution, which imposes a duty upon the state and all state organs, including the judiciary, to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And there must be compelling reasons to limit the right to liberty. What are compelling reasons were settled in the case of the Republic versus Mugunya, which I've already referred to. And similarly, in the case of the Republic versus Harrison Nju Njeru, a Kerugoya High Court criminal case number 9 of 2015, the court defined compelling reasons as not just any reasons, but a reason that must be convincing as to justify the refusal to grant bail pending trial. Further, in the case of Mohammed Haga Abdul Rahim and another, 2012 Kenya law report, the court held that compelling reasons would such be reasons that is forcefully convincing to persuade this court that something is true. The prosecution has raised the issue that the respondent is likely to be charged with the offense of incitement, but have not presented any holding charge before this court. I'm also guided by the case of Priscilla Jemutai versus the Republic, criminal application case number 319 of 2002, where the court held where the charge against the accused is more serious and the punishment heavy, there are more probabilities that the incentive to abscond, there will be incentive to abscond, whereas the case of minor offenses, there may not be so much incentive. I'm satisfied that the seriousness of an offense and the seriousness of a punishment is not a compelling reason to deny the accused person's right to bond. Article 21 and 23b bind state organs to apply human rights and adopt an interpretation to the Constitution that favors the protection of human rights. The Bill of Rights also protects witnesses and victims of crime, and the successful prosecution of crimes depends on securing reliable evidence, including testimony of witnesses. This court is satisfied that the place has put in place measures to protect witnesses who may be intimidated or threatened by the accused persons, and the State Witness Protection Agency. The court is also satisfied that the state has adequate resources to overtly and covertly monitor the movement of the accused persons, including intercept the accused persons' communication. I'm therefore satisfied that the interference of witnesses will not be a compelling reason to limit the respondent's right to liberty. The court, as one of the criminal justice agencies, cannot operate in a vacuum without taking into account the impact of crime to national security and the economy. The court also takes judicial notice that alarming utterances like the ones made by the respondent caused a lot of damage, loss of lives during the post-election violence. I'm satisfied that the prosecution has not established that there are compelling reasons to limit the respondent's right to liberty. The affidavit by Corporal Nyang'au does not state that the respondent has the contacts of the witnesses or that the respondent will intimidate witnesses. The affidavit does not state that the respondent has the capacity to interfere with the government's cybercrime lab. The court is also satisfied that the state has massive resources to overtly and covertly monitor the respondent and can intercept his communication, can monitor his movement. The court notes that the prosecution has requested to detain the respondent for 7 days. The court is satisfied that the state's adequate resources to investigate the case against the respondent. The state has adequate resources to investigate the case against the respondent without limiting his right to liberty. The court also notes that prolonged pre-charge detention can result to arbitrary detention and is incompatible with the constitutionally guaranteed presumption of innocence. In limiting the right to liberty, the court must interrogate whether the detention is appropriate, reasonable, and necessary. The Constitution obligates the state to ensure that all guarantees of due processes are respected when persons are alleged to have committed serious offenses or are charged, detained, and prosecuted. And the court makes the following orders. The respondent is granted a conditional bond of Kenya shillings 5 million with one surety of a similar amount. In the alternative, cash bail of Kenya shillings 2 million. The respondent to report at the CID headquarters once a week. The respondent's free speech rights are limited, that he should not make any comments on the case under investigations, he should not conduct any witnesses, and he should not intimidate any of the witnesses, whether potential or imagined. The respondent should not conduct any of the witnesses either through proxy or personally, and this is the ruling of the court. The prosecution has a right to appeal.
Much obliged, Your Honor. We kindly request for a typed copy.
It's already typed, so it's just a matter of asking the IT. My laptop does not communicate to the printer. I do not have a printer in my chambers.
Much obliged, Your Honor. Thank you so much.
Live pictures there from a Nakuru court where Meru Senator Linturi was supposed to know his fate, as you've heard from the Chief Magistrate, that is Chief Magistrate Edna Nyaloti. She has said that of course, interfering of witnesses is not a compelling reason to limit the accused of their liberty, and of course, therefore, that means the senator has been freed on a bail, on a cash bail of 2 million shillings. He's not supposed to report. He's supposed to report to the DCI once a week, and also should not contact any of the witnesses during this period. Of course, we want to take a short break here on News Center. When we come back, we'll be crossing over live to the Senate, where those proceedings have started. The debate of the political amendments bill, which was supposed to start today at the Senate in a special sitting. We'll be crossing over live there once we get back.